students, welcome to the class. Welcome to the class on Indian polity and constitution. As part of the Indian polity constitution Tspsc Group 1 series, today in this class we will continue with the same topic which we have discussed in our last class, and that is your fundamental rights. Fundamental rights being very important for your exam, we are going to see this fundamental rights in two sessions. We have already completed the first session and now we will be starting our second session on fundamental rights. As we discussed a few important objective type questions related to fundamental rights in the last class, today in this class I will touch important articles with respect to fundamental rights. Now in this fundamental rights, as I discussed earlier, which is mentioned from article 12 to 35 of the constitution, fundamental rights are guaranteed directly by the Indian constitution. Fundamental rights are inspired from US constitution where they are directly enforceable. In the last class, I was mentioning about article 32, which is very, very important. And specifically article 32 clause 3. According to article 32 clause 3, Parliament by law can give authority to subordinate courts for enforcing fundamental rights, Now today in this class, I want to touch the concepts like reservations, right? We will dig deeper into article 21, article 22, article 25. I ensure that you get clarity over few other provisions of fundamental rights. Now why waste time? Let's directly begin the first objective type question, which is useful for your group 1 prelims Tspsc for upcoming exam. First question, here we go on your screen. Look at the question, friends. Consider the following and choose the correct statement. See, I told you in the last class, I keep on repeating this. Our intention with this series is to make you understand what are the important topics, what are the important areas to concentrate in Indian polity constitution, as well as how the question can be framed, how the question can be asked, and how to answer each and every question is also what we are going to discuss or what we are going to learn in this series of sessions. So I wish you all to concentrate on the wordings of the questions, as well as how the question is framed, as well as how you need to answer a question. May it be an elimination process, may it be a factual thing, may it be a statement related questions, may it be interlinking, may it be match the following. We will learn through these sessions how to answer each and every prelims based question for our upcoming Tspsc Group 1. Let all be ready. My intention is to make sure that you get as many as questions correct for polity, from polity and constitution in your upcoming Tspsc Group 1 examination. Now look at this question. Consider the following and choose the correct statement. Article 14 discusses the concept of equality before law and equal protection of laws. Okay. Article 15 clause 6 and 16 clause 6 is added by 103rd Constitutional Amendment Act 2009. Now let us see. See, Article 14 generally talks about three major concepts. The first one is called rule of law. according to which law is powerful, according to which law is supreme. This concept of rule of law is given by A.V. Dicey in his book Administrative Law Reforms. In his book Administrative Law Reforms or Theory. In his book, he has developed the concept of rule of law. According to rule of law theory, in any country which follows rule of law, in that country, especially, law is considered supreme. And in the eyes of the law, everyone are equal. All are equal in the eyes of the law is called equality before law. A law which is supreme, and in front of that supreme law, all are equal in the eyes of the law, irrespective of the gender, irrespective of the caste, irrespective of the religion, irrespective of physically handicapped or physically fit. All are equal in the eyes of the law. This is the concept of lady justice. This is called lady justice concept. You see this lady justice in courts, where there is a lady standing and she is called lady justice. In front of her, all are equal. Even though everyone are equal in the eyes of the law doesn't treat you equally. The law doesn't treat everyone equally. That is called equal protection of laws. Although everyone are equal in the eyes of the law doesn't treat everyone equally. Law treats everyone as per their capacity. Law treats everyone as per their capabilities. I will give you a small example so that you will get concept clear. A person studying in 6th standard, a person studying in 8th standard, right? Two boys or two girls who are studying in 6th and 8th standard, both are equal in the eyes of the law. But both the students are not given the same question paper in the examination. A 6th standard student is given a question paper to test according to his rationality, according to his discipline, according to his capabilities. And similarly, the 8th standard student. Even though both the students are equal in the eyes of the law, both are not given same question papers in the exam. The law doesn't treat these two equally because of their capabilities. The law doesn't treat few people equally because they need reservations. And this concept of reservations in the Indian Constitution is called positive discrimination. This is called positive discrimination. This is called positive discrimination, the concept of reservations. Even though in the eyes of the law all are equal, the law should, take the charge as fatherly treatment towards empowering some people in the society, right? This is called positive discrimination. So, if you look at this explanation, statement 1 is absolutely correct. Now, what is Article 15.6 and 16.6? Article 15 Clause 6 and 16 Clause 6 talks about economically weaker sections reservations. Reservations to economically weaker sections. According to this two article, up to 10% reservations is guaranteed, and this is not an old concept. This is added by an amendment, and this amendment is 103rd Constitutional Amendment Act of 2019. This act came into force on 12th January 2019. 12th January is observed as National Youth Day, Swami Vivekananda's birthday. So the answer is C. Consider the following and choose the correct statement. Again, correct statement. Okay. The original constitution did not contain provisions to provide reservations for SCs and STs. The original constitution. What is the meaning of original constitution? Constitution which is not amended. Constitution which came into force on January 26th, 1950. So on January 26th, 1950, when Constitution came into force, without amendment, without any amendment, that is called original Constitution. As on today, 105 amendments took place to the Constitution of India, right? So no amendment is an original Constitution, and this statement is absolutely correct. In the Constitution of India, Article 15 Clause 4 talks about reservations to SCs and STs. And this Article 15 Clause 4 is added by first Constitutional Amendment Act of 1951. First Constitutional Amendment Act of 1951 added Article 15 Clause 4, which provide reservations in educational institutions except the minority educational institutions for SCs and STs. So this is correct. Now look at the second one. In India, we have reservations given to SCs, STs, right? OBCs. Now presently economically weaker sections. Of course, yes. Now my point here is, according to one case, Supreme Court has directly said, Indira Savani case, I am quoting, Indira Savani case, Supreme Court said, reservations at any cost cannot go beyond 50%. But under special circumstances, reservation can be given more than 50%. That is what Indira Savani case Supreme Court said. But in which case, the cap of 50% was brought by Supreme Court is what I asked in the second statement. And this is absolutely correct. Many people think it is Indira Savani case. No. It is in Balaji versus State of Mysore case, Supreme Court bought the cap of 50% reservations. And this is correct. And in Indira Savani case, Supreme Court said, in special circumstances, this cap can be increased by 50%. So answer is C again. So very easy question, but very, very important for your exam. These type of questions will be asked, right? After Balaji versus State of Mysore only, SC/ST reservations are also there. OBC reservations by Mandal Commission. BP Mandal Commission recommended 27% reservations to OBCs. And according to Office of Memorandum passed in 1991 by PV Narasimha Rao government, these reservations to OBCs was bought. And this was challenged in Indira Savani case of 1992. In 1992, Indira Savani case, Supreme Court gave a clear-cut guidelines on how the reservation should function in India. These guidelines are very, very important for the exam. I want everyone to have a look at that guidelines. Which article of the fundamental rights is linked to 367 directly? See, the word directly is important. See, Article 3, what is Article 367? Article 367 talks about explanation to certain terminologies. Explanation to certain constitutional terminologies. That is what Article 367 is all about. Now, what is Article 25? It talks about right to religion. Right to religion. Now, this is not linked to Article 367. Article 22 talks about certain protections to detained persons. Detained persons. Article 14 talks about right to equality. Right to equality. All these three are not linked to 367. The only article which is linked to Article 367 is Article 12. How, sir? I'll explain it. See, if you look at Article 12 of the Constitution, Article 12 talks about definition of state. Definition of the term state. State means 1. Center and the parliament. 2. State and the state legislature. 3. Local authorities. And 4. Other authorities. Other authorities. Now look at this. It says local authority. Now what is local authority? Vaguely we can define something. According to Article 12, if you want to know what is the meaning, what is the definition of local authority, it asks you to refer to Article 367. Article 367 says, to know what are the institutions which falls under local authority, do one thing. There is a law called General Clauses Act of 1897. Now, there is a law called General Clauses Act of 1897, which defines what is local authority in section 3 of subclause 31. To know what is local authority, you go to General Clauses Act. In General Clauses Act, whatever definition of a local authority is given in section 3, subclause 31, you take the same definition into Article 12. So that is how Article 12 is linked to 367. Which articles of the Constitution discuss about both preventive, punitive? Just before I told detention. What is the meaning of detention? Arrest. Arrest. See, what is the mean? Arrest, detention are of two types. What is punitive? After crime. When someone is arrested after crime. Right? When someone is arrested to prevent the crime. Before committing the crime only. To prevent it. To prevent it, before only they are arrested. Before committing a crime only, the police arrest you. That is called preventive detention. It is famously called PD Act. Preventive Detention Act. These things are mentioned in Article 22 of the Constitution. Article 19 talks about certain freedoms guaranteed to the citizens. Presently, 6 freedoms are guaranteed. In the original Constitution, we have 7 freedoms guaranteed. Now, Article 20. Article 20 talks about protections to convicted persons. Protections to convicted persons. Those people who are convicted of a crime, for them there are such 3 protections available. No ex post facto, no double jeopardy, and no self-incrimination. So, this is your next question. The answer is 22. Sir, what are the protections available to detained persons? I will name few. 1. Whenever the police is taking you in the custody, whenever police want to arrest you, you have certain protections as per Article 22 for both punitive and preventive. Protection number 1, you need to be informed of what are the charges you are arrested under. Right to be informed. You should know why are you getting arrested. If you are not getting to know why are you getting arrested, that is unconstitutional. That arrest is not valid. 2, you have right to consult your attorney, advocate. 3, after the FIR is filed, within 24 hours, excluding the travel time and excluding the public holidays, you should be placed within the nearest magistrate. These are the 3 common protections available to both punitive detention and preventive detention persons under Article 22. Right to sleep is a fundamental right under Article 21, a fundamental right under Article 19, or a natural right. See, what is the meaning of natural rights? Anything which is given by nature. Right to sleep is obviously natural right. See, sunlight, air, right? Sleep. All these are natural rights given naturally by the nature. So 3 is correct. So this is wrong. Either it may be 1, 3, 2, 3 or 3 only. We know the 3 is correct. No, right to sleep cannot be a freedom, right? It is not a freedom. But Article 19 talks about certain freedoms. Right to sleep is part of right to life. Right to life and personal liberty. It is part of liberty. So 1, 3 is the answer. B is the answer. Article 19 doesn't deal with right to sleep. Article 19 talks about certain freedoms guaranteed. Like for example, freedom of speech and expression. freedom to form associations, freedom to assemble peacefully, freedom to go anywhere in the country, freedom to reside and settle anywhere in the country, freedom to possess any occupation. All these are the rights guaranteed under Article 19. This is a current affairs based polity question. Supreme Court recognized sex workers as profession and said it is part of which fundamental right? Sex workers or prostitution is not considered a direct profession in India. But Supreme Court mean that it is a profession by a way of life, by a way of livelihood. They want to involve in these activities for their livelihood, for money, for increasing standard of living, or for their living. It cannot be called a direct profession. This profession is not what we see. This profession in the eyes of the Supreme Court is for their livelihood. So recently only Supreme Court said this right of the livelihood for the prostitutions is a right under Article 21 of the Constitution. So it comes under right to life and liberty. It is not Article 19(1)(g). Don't get confused here. Why? Because Article 19(1)(g) talks about freedom of profession, freedom of profession, trade, business, etc. But even though it is recognized as a profession and trade, Supreme Court did not mean that it should be done as business. Supreme Court means the prostitution involved the livelihood concept, the standard of living concept. So answer is A. This is not. So this is correct. So recently Supreme Court has come up with this judgment. See, again I am repeating this. I told you Article 21 is the shortest article, and most reviewed article. Most reviewed. See, I will tell you few cases which are directly linked to Article 21. A.K. Gopalan case. A.K. Gopalan case. 𝗧𝗦𝗔𝗧 𝗚𝗏 case. 𝗧𝗦𝗔𝗧 case. 𝗂𝗶𝗍𝗧𝗧 case. 𝗂𝗶𝗍𝗧𝗧 case. Not only that, Menaka Gandhi case. Menaka Gandhi case. All these are directly linked to Article 21. It brought golden triangle theory, Menaka Gandhi case, and introduced, Supreme Court introduced this concept of golden triangle theory, according to which all the laws shall be aligned to Article 14, 19, 21. If any law is against any of this article, that law is declared invalid or unconstitutional. Very important. See, Article 13 is a very important article. I always tell in the class also that Article 13 protects the fundamental rights. Here Article 13 protects the fundamental rights. Look at this. Which of the following doesn't come under definition of the term law as per Article 13 clause 3? See, Article 13 talks about 4 important provisions. 1, 2, 3, 4. Article 13 clause 1 talks about pre-constitutional laws. Pre-constitutional laws, meaning laws before 1950. Article 13 clause 2 talks about post-constitutional laws. Article 13 clause 3 talks about definition of a term law. What is the meaning of law? And Article 13 clause 4 talks about the relationship between 13 and 368. What is the link between Article 13 and 368? This Article 13 clause 4 is added by 24th Constitutional Amendment Act 1971. Right? This is newly added. Now the question here related to what is 13 clause 3. Which of the following does not come under article 13 clause 3? What comes under the definition of law? A law made in the parliament, a law made in the parliament, a law made in the state legislature, a law made in the state legislature, an ordinance given by President of India and Governor, and GO, government order given by government of the center and state. This is also called executive order, right? Customs, usage into practice since many years. All these are part of the term law. Then which doesn't come under the definition of the law? Circulars, right? Circular doesn't come under the definition of the law. Circular doesn't come under the definition of law. So answer is D. Answer is D. Choose the correct match. So this question is linked to your articles and your Supreme Court judgments. Article 15, 𝗬𝗂𝗧𝗏 case, very important. Article 15, 𝗬𝗂𝗧𝗏 case is a reason for introducing Article 15 clause 4, giving reservations to SCs and STs. 𝗬𝗂𝗧𝗏 case is a very famous case which made it evident that there is a conflict between fundamental rights and DPSP, Directive Principles of State Policy. Article 19, Vishaka case. No, this is wrong. Vishaka case is linked to sexual harassment in workplace for women, and this is linked to Article 21, not 19. Article 14, 𝗵𝗺𝗧𝗏. Article 𝗵𝗺𝗧𝗏 case is not only linked to 14, it is also linked to 21. So answer is 1 in 3. B is the answer. Very important, Amma. Consider the following and choose the incorrect statement. See, this is very important word here. Rehabilitation and Resettlement Act of 2013 is linked to Article 31 of the Constitution. See, according to this act, whenever the government or the state take away your land pooling, when they take away your land, if it is urban area, you need to give 2x into the government price. If the price of the land per acre is 1 lakh, if it is in urban area, the government should give 2 lakhs, right? If it is a rural area, it is 4 times. So if it is 1 lakh in the villages, it is 4 lakhs is what you need to do. Now, this statement is actually correct because Article 31 talks about right to property. Parliament may by law can take away this rights. According to ADM Jabalpur case, writs under Article 32 cannot be suspended even in case of national emergency. See, this statement, whenever you look at it, you seem it to be correct. You think it is correct, but it is actually wrong. I'll tell you. ADM Jabalpur case is also called habeas corpus case. It is the another name of this case is habeas corpus case. So, not all the writs can be suspended. It doesn't talk about all the writs. It only talks about habeas corpus. So, that's why this is wrong. So, here choose the incorrect statement. So, answer is B. Answer is B. In Ayodhya case, Supreme Court involved or invoked Article 142. Now, what is Article 142? Article 142 talks about complete justice. This is also called curative petition, right? Because Supreme Court was in an opinion that all parties involved lost their fundamental right guaranteed under. See, whenever you see Ayodhya, it is nothing but religious rights. So, the only option here is Article 25, right to religion. Who are the parties involved here? Ram Lalla Virajman, Nirmoyi Akara, Suni Wakbod. All the parties involved got justice. Ram Lalla Virajman was given 5 acres disputed land of Ayodhya. Sunni Waqf Board was asked to give 5 acres by government of UP or government of India, in UP only, somewhere. Allot 5 acres of land. Nirmohi Akara was made a permanent trustee in Ayodhya Temple Trust. So all are given justice because everyone lost their right under Article 25. That is the meaning. So these are your few other questions related to fundamental rights. In the last class also, last session also, we have discussed about fundamental rights. And today as well, in this session, we have done the fundamental rights in detail. All the questions which we are discussing are important and expected for your exam. So please focus, happy learning, keep learning. Thank you very much. I'll see you in the next class again with directive principles of state policy and fundamental duties. Till then, again, keep learning. Jai Hind.